Hello, and thank you for joining us for a Protecting Your Family update on digital estates. My name is Justin Meyer, and I'm attorney with Meyer & Associates, Counselors at Law, PLLC. Before we get started, a brief disclaimer. Nothing that I'm going to say here today is legal advice. It should all be considered general information. Before making any decisions based upon what we talk about today, you want to make sure you speak with an attorney licensed in your state, or an accountant or CPA or other financial professional. A little bit about me. I'm an attorney licensed in New York, New Jersey, and Florida, but I'm based here in Hauppauge, New York. I've published articles on investing and due diligence best practices, as well as one for the Suffolk County Bar Association on digital assets. I've been looking into this area for a little bit now. I have also advised clients from their 20s and 30s all the way until their 70s and 80s on different aspects of estate planning. Let's talk about what we're going to accomplish today. Our goals are to go over what are digital assets, how you should plan for others to access them, and then some special concerns. So first, what are digital assets? Digital assets are any online account, including Facebook, LinkedIn, Twitter, any blog that you may have, or possibly even that you contribute to, and your online banking and brokerage accounts. Now, these last ones also have real-world assets attached to them, but they are considered digital assets. Your cell phones, your laptops, your MP3 players, your e-readers are all considered digital assets as well because they have digital components to them, especially if you have information that you keep on the cloud for them. Barnes & Noble account, an Amazon account, an iTunes account, these are all digital assets, and these are ones that may have actually cost you money. The reason why these are important, we'll talk about these later as well, is because of the licensing and the amount of money that some people put into them. So let's take a look at the current law. Right now, there are very few states that have any laws regarding digital assets. New York had a law that never got out of committee in the state Senate. And while there have been several pushes to give executors access to estates, both in New York and elsewhere, not all of them have ever gotten off the ground. The ones that have are not fully adequate yet. There is a multi-state push to get something together. They're saying that may take until 2015. And then there's also federal law to consider. Federal law works against the executor. Federal computer access and privacy laws may be at issue and may actually hurt an executor or somebody trying to get into a digital estate after the fact. So why does it matter? What's the importance of it all? Well, one thing to consider is what should happen to your social media accounts after you die. Do you want your Facebook account or your Twitter account to keep going? Do you want it to be discontinued? Do you want it to be deleted? Do you want the information to be taken off of it? Or your LinkedIn account? Another digital asset, email. What information is in your email that your executor might need or that they might want? How many pictures do you have in your email or documents do you have in your email that you may never have downloaded before? What about letters that you may have sent to people that they may decide that they want? What about banking information or passwords that may be sent to your email that people decide that they need? Another consideration is, do you have any intellectual property that needs to be protected or that may be worth something? If you write for a blog, that blog may be worth money. If you have a large Twitter following, that may be worth money to people. If you have a domain name, that may be worth money. And finally, how much money have you spent on your digital assets? So, having broken down why it's important and what they are, how do you make sure that other people have access to them? Well, the easiest way is to write your passwords down. We recommend you keep a book with all of your estate planning documents, and in that book, we recommend that you keep a list of your passwords. Keep them up. You keep the password list updated, easy as pie. The next easiest way, and this doesn't work for all of them, is to give them access after death. Gmail makes this increasingly easy to do. You can sign up through their website, and they will contact a person you specify after they haven't heard from you for 6 months or 9 months or some period again that you specify. Microsoft, upon notification of death, will open up your account to your executor or next of kin. Yahoo, on the other hand, will resist all of this. Yahoo has been fighting in court any opportunity that they get. They are trying to keep executors and next of kin from getting access to email accounts. They are trying to terminate accounts upon death. So you do want to be wary, if you have a Yahoo account, of that. So what are some special concerns? The first one is intellectual property that you may own. Some estates contain intellectual property that might have a value. Blogs, for example. We come back to that. If you have a blog that you've been running, or one that you've been posting to where you control your own articles and you own the rights to your own articles, they may have earned money in the past and they may be worth something now. Blogs can be resold. Domain names can be resold. Dewey LaBeouf is a law firm that went out of business, went bankrupt. They had the domain name dl.com, which is now at auction for $200,000. Domain names, especially certain ones, can be very valuable and can sell for hundreds or thousands of dollars. So if you have a domain name, that is something that you need to consider. If you have a blog that is earning income, that is something that you need to consider. An Amazon affiliate account is also something you need to consider. Advertising revenue as well should be considered. If you have intellectual property, and especially if it is earning money, what do you want to happen to it after you die? Do you want it to be continued and sold? Do you want it to be terminated? These are things that you want to be able to decide, just like you would be able to decide what happens to your house or to your car by using a will. Another special concern is with iTunes and Amazon. Now we focus on these two because they're the biggest, but they're not the only ones. Barnes & Noble has similar provisions. If you remember several years back, people who bought 1984 off of Amazon on their Kindles found that they woke up one morning and the book was gone because it had not been officially released and Amazon had released it too early. Everybody was in uproar. The irony was great with the book that this had happened to. And what Amazon said was, you didn't actually own the book. What you owned was a license to read the book in that file. iTunes and Amazon believe that you do not own the file that you are purchasing. So, therefore, neither of them give survivorship rights. They both claim that you have purchased a license to listen to the song, play the song, read the book, use the app, and that on your death, these licenses terminate. The law has not yet really addressed this issue, and it's unclear how it will fully play out. The easy recommendation is that you pass on the devices. If you have a large MP3 collection, give somebody your MP3 player along with the password. If you have a large book collection on Amazon, you can give somebody the Kindle and the password. There are trusts that people have started creating for these accounts. If you're spending a lot of money, if you're spending $10,000 to $20,000, then that's something that's worth discussing. But a trust itself may not be worth it. And because these trusts have not yet been tested, have not yet been proven, it's unclear whether or not they'd work. This is a very gray area, and I don't know exactly how it's going to play out. Various people have made different arguments, and you do want to be cognizant of that. You do want to be cognizant of the fact that this is an area that the law really hasn't caught up on yet. And people may end up spending significant amounts of money trying to figure out exactly how their assets can be passed down. But if you do not plan for it, then you won't be deciding it. Amazon will just take your money and we'll just delete the files. Some other resources for you. We talk about this topic on occasion and other estate planning and business topics as well on our legal blog, legalnotes.meyeresq.com. We also have a monthly newsletter that goes out around the 15th of each month. You can sign up for it at meyeresq.com. I hope you found this informative. If you have any questions, you can feel free to email me at jmeyer@meyeresq.com. Again, my name is Justin Meyer, and thank you very much for joining us.